welcome back to Legal Threads. I'm Chat, and today we're taking a trip to Louisiana to look at a case that wrestles with the boundaries of self-defense, the role of words in provoking violence, and what happens when a trial court cuts things short too soon. This is Touchet v Hampton. Here's the setup. Purvis Touchet had worked as a sales manager at Hampton Mitsubishi, owned by Mark Hampton, for about 3 years. After leaving the job, Touchet didn't exactly move on peacefully. He allegedly harassed Hampton with repeated phone calls and voicemails, some of them vulgar and even threatening. On October 22, 2002, Hampton had enough. He went to Touchet's new workplace, intending to confront him face to face. When Hampton entered the office, he later claimed Touchet cursed at him and looked like he was about to strike. Hampton responded by hitting Touchet repeatedly until a coworker intervened. Touchet, still seated the entire time, filed a civil lawsuit for battery, seeking damages for his medical bills, pain and suffering, and humiliation. The trial court, after hearing just the plaintiff's case, granted Hampton's motion for involuntary dismissal. The judge reasoned that Touchet's past threats and his behavior that day justified Hampton's fear, making the blows self-defense. But on appeal, the Louisiana court saw it differently. The law is clear: mere words, even threats, do not justify battery. Prior threats, unless paired with an actual and imminent danger in the moment, don't count as self-defense. And co-workers testified that Touchet never tried to strike Hampton. He stayed in his chair and only covered his face while being punched. Even if Hampton was startled, the court said, he could have walked away. His repeated blows against a seated man went beyond what the law recognizes as reasonable self-defense. The appellate court reversed the dismissal and sent the case back for further proceedings. So what's the lesson? Touchet v. Hampton reinforces that self-defense in tort law requires immediacy and proportionality. Past words, insults, or even earlier threats don't open the door to physical retaliation later on. And once the threat is gone, the privilege ends. Courts will look closely at whether force was truly necessary, and they'll overturn trial courts that let defendants escape too easily under the banner of self-defense. And that's the thread for today. Remember to like and subscribe for more legal threads.